Welcome and good afternoon. This is Brian Tate with the IPA, the Innovative Payments Association. We thank you for taking the time to join us for our Summer of Learning series. Today, I'm very pleased to share with you that we have Libby Shaffer from Dinsmore with us. And her presentation today will focus on strategies for defense and settlement of mass volume arbitrations. Libby and Dinsmore have been a member of the IPA for a number of years, and they're very steeped in this material and subject matter. So please take the time to listen today. If you have questions during the conversation, feel free to put them in the chat. We'll be happy to take them along the way, or you can save them towards the end and then ask your questions. We're pretty flexible over here. Before we jump right into it, I do want to just take a moment to introduce Libby to everyone. Libby is an equity partner at the law offices of Dinsmore Shohl. She developed a substantial practice representing several of the country's largest prepaid card issuers and program managers. Libby has successfully resolved and prevailed in hundreds of arbitrations alleging violations of the Electronic Funds Transfer Act and Regulation E, pertaining to alleged unauthorized transactions, improper holds, system outages, and delays in the posting of ACA transactions to prepaid debit cards. Libby has also represented several clients in mass volume arbitrations before the American Arbitration Association. Libby will speak on today's conversation, as I mentioned, strategies for defense and settlement of mass arbitrations. And she's here as a resource for everyone, even after today's presentation. So one more time, I just want to thank Libby for being here, and you now have the floor. Welcome.
Great. Thank you, Brian. It's a pleasure to be here, and I appreciate the invitation from IPA. Thanks to everyone who's joining today. I'm excited to present on the strategies for defense and settlement of mass volume arbitrations. So first, the question is, what is a mass volume arbitration? And it's a process in which dozens or tens of thousands of individuals file individual arbitrations against a company in a coordinated effort. And the reason this has become a big deal is that originally companies who entered into consumer contracts would often have an arbitration provision. And just about all of the companies that you work with right now, who you work for, probably have an arbitration provision. And those arbitration provisions probably include a class action waiver. That's the reason that a lot of people put these provisions in their contracts to begin with, is that they wanted to avoid having to go to a class action. The problem is that generally in these arbitration provisions, there's going to be a provision that says that the company will pay for all of the filing fees that are associated with a consumer filing an arbitration demand against it. The reason that those provisions include that is because otherwise courts may find them to be unconscionable. They might say that a arbitration provision that's entered on a take it or leave it basis and contains a waiver of the ability to bring a class action is somehow unconscionable because it deprives low value claims from being able to be litigated in court. For instance, as we'll talk about later today, there are fairly substantial filing fees that are associated with AAA. And so if you have a very low dollar case, let's say your case is only worth $200 and the filing fees itself eclipse that amount, then those claims may never be brought. And so in such a situation, courts find that the provisions are unconscionable. And so to avoid that, companies started including consumer-friendly provisions like fee shifting so that any claims brought against them, they will reimburse the filing fees. So all of that collided into a situation where very entrepreneurial consumers counsel realized that if they can find enough individual claimants and bring those individual cases in arbitration, then they have significant leverage over the company, because all of a sudden the company has to pay hundreds of thousands, or as we've also seen, several $1 million in filing fees up front. And so, my clients have faced this. when we first started facing it, we said, oh my gosh, this is extortion, because that's exactly what it feels like, that you have these low dollar claims, sometimes that even lack complete merit, but can be brought and have you forced to pay these filing fees up front. And so the consumer counsel would say, hey, don't you want to settle this case for less than even the most basic filing fee of $500, which, as we'll talk about, also, becomes much greater than that after the initial stage. It ends up being about $3,400 per case. And so wouldn't you want to, for example, settle for $100 a claimant rather than pay the initial $500 intake fee? And so that is a situation that we find ourselves in, and that is what's referred to as a mass volume arbitration, where there are several individual claimants filing individual claims, but they're all against the same company, and they are all alleging the same set of facts. So it's cases you typically see in a class action, but because of the class action waiver and arbitration provision, they're now being filed in arbitration with significantly more costs to the company and the ability to try to extort a large settlement out of the company. So that is the context of what we're dealing with today. So the topics that we're going to discuss today are a more detailed examination of the arbitration fees. As I said, that is a big motivator in the plaintiffs or the claimants' desire to bring these mass volume arbitrations. So you need to have a really good understanding of the arbitration fees and when they are charged. We will also talk about early strategy. As I said, when these mass volume arbitrations are being filed, you need to decide early whether these are going to be settled or whether they're going to be defended. And there's a lot of different factors that we wanted to consider there. Next, we'll talk about counterclaims for fees and costs. This is a way to push back on the consumer's attorneys to limit some of the leverage that they have over the company. Next, we'll talk about briefing strategies for this volume of claims. And then finally, we'll talk about avoiding what I call extortion. So we'll talk about how to avoid being in this mass volume arbitration context altogether. So first, the discussion of the arbitration fees. So I'm talking about AAA, the American Arbitration Association, because that's where I have arbitrated all of my mass volume arbitrations, and that's where we typically see these being brought. There may also be some of these mass volume arbitrations brought with jams, but most of the contracts we see choose AAA as a forum because supposedly their fee structure is more beneficial to the entity that's paying than the fee structure in jams. So just want to note that this is AAA. There are other fee structures if you're with a different organization. But if you find yourself in this situation, most likely you're going to be with AAA. So one thing to consider is if these are desk arbitrations or if they are hearings. So a desk arbitration, it means that everything is decided on the briefs. And of course, a hearing means that everything's decided at a hearing, which would either be virtual or in person or just by telephone. In the mass volume arbitration context, however, everything is filed as a desk arbitration. And this is done because of the fact that there's such a volume of claims that the consumer's attorneys don't have the ability to have a hearing on each of these. And so instead, what they're trying to do is to have templates that they can use and spend as little as time as possible on each individual claim because they just don't have the resources to really arbitrate this with the detail that you would expect of just an individual arbitration versus a mass volume arbitration. An interesting side note there is that in dealing with one of the mass volume arbitrations for a client, we had about 70,000 claims that were filed against us. And so you can imagine the scope of the fees that were at play. And we were moving forward with arbitrating these rather than being extorted, basically. And in one of my calls with the arbitrator was saying that he really thought that the consumer should have their day in court and that this should be done for a hearing. And I got a kick out of it because I knew that the consumers' attorneys would basically freak out if they had to conduct multiple hearings. And so they were having to argue why their clients didn't need the due process of a hearing. So long story short, everybody's going to want a desk arbitration. The defense side wants it as well for the same reasons that we can use templates and models and try to have some administrative efficiencies. But at the same time, it is kind of fun to call their bluff if the arbitrator wants to have a hearing, because usually we on the defense side are better equipped to handle that. For instance, in the mass volume arbitration with the 70,000 different arbitrations, I was working with another large firm in Silicon Valley, as well as a firm in Chicago and a firm in DC. So we had a lot. We had a lot of attorneys at our disposal compared to the single law firm for the consumers. So we'll be in desk arbitration. There are new rules that have come into play with respect to mass volume arbitrations. I'll start with a typical individual arbitration. And what you would see there is that the consumer pays $200 and the company pays $300 as quote unquote an intake fee. However, that $200 from the consumer is then reimbursed by the company because of the fee shifting provision within the arbitration provision. So that amounts to a $500 intake fee. The intake fee is required no matter what. And so even if the matter is withdrawn the next day or settled the next day, you have to pay that $500. There's no getting around it. Even if like I said, even if the consumer's attorney actually withdraws that arbitration demand, you as the defendant is to have still paid that $500. And then after that, they charge. So after that, there's a time period in which you may be able to settle a claim, and they allow for that, which is great. But if you decide not to settle the claim and to move forward, then they will charge a $1,400 case management fee, which is the fee that goes to AAA for their supposed work in administering these arbitrations. And then there's also a $1,500 arbitrator compensation for the desk arbitrations. So that's how it all adds up to $3,400 per arbitration. Now, like I said, there are some new rules that went into effect. When was that? I think maybe October or November 1st of 2020, maybe, where there's now a sliding scale for mass volume arbitrations. So I just described to you the individual arbitration, and that's very expensive. And so they said, well, what about when we have a huge volume of claims? Should there be a reduction in fee based upon administrative efficiencies? And so what they did is they came up with a sliding scale. And so under the new sliding scale for multiple case filings, the consumer is paying somewhere between $100 or $50 per case for the intake fee rather than $200. And then the business is paying anywhere from the normal $300 to $225, $150, or $75 based upon the volume of claims. So I don't have the list in front of me, but let's say if it's 100 claims, you're going to pay $225. If it's 1,000 claims, you're going to pay $150. If it's 10,000 claims, you're going to pay $75. And so that's how AAA tried to address some of the fee issues associated with mass volume arbitrations. But as you can see, that really doesn't do very much. Even at the best case scenario, because of the fee shifting provisions, the consumer would pay $50, the business would pay $75, so the business ends up paying $125. And if you have 70,000 arbitrations, all of a sudden you're paying a whole lot of money, and all of these claims could basically be withdrawn and you wouldn't get a refund on that. What the new rules did not do is they did not change the case administration fee of $1,400 and the arbitrator's compensation of $1,500. So that was very frustrating because, again, we're still dealing with a very large dollar figure for each of these mass volume arbitrations. So there are ways to try to reduce the fees that are associated with mass volume arbitrations, and that would be by negotiating with AAA and opposing counsel. I have had success in doing that, but it's been specifically when opposing counsel agreed to a limited fee. So, for instance, we had about 250 arbitrations involved in one of the mass volume arbitrations against a prepaid company. And the opposing counsel agreed that the arbitrator compensation should be reduced to $750 from $1,500, so long as the arbitrators would agree to accept that rate. And the administration fee was changed from $1,400 to $1,000. So we were able to negotiate a much lower rate, but that's hard to do because basically the Consumers Counsel is then working against their best interest because this is all fee driven. They want to put as much leverage on the company as possible to have a high fee that they have to pay in order to extort a settlement. And so where you would hope that opposing counsel might actually care about having these claims decided and getting relief for their clients, that's not what's driving this. And so if they wanted to have efficiencies in place, they would have some agreements on the fees and on the structures, but oftentimes they don't want to do that.
Libby, can I ask a question if that's okay?
Yeah, sure.
In terms of the cost of this whole process, and everything I've read is you're perfectly on point about counsel and just kind of the cost of when you're lowering the cost or you're negotiating the cost on even on the smallest thing, what kind of impact does that have on the kind of representation that helps the class bring these cases? Does it, do you see, a big firm, for instance, that files a class action, they go, look, we're not able to make any money here, and they back out, or the next time a similar case comes along, they're not involved. Does the cost have an impact on representation?
I don't think the cost has an impact on representation because there's still going to be significant leverage with any mass volume arbitration. Even if we're paying, for instance, if we're only paying, $1,700 as opposed to $3,400, that's still a lot of leverage that the consumers have against us in order to try to extort a settlement and make a lot of money early. That's what they'd really love to do, is say, I've got all of these claimants, we're going to file all of these, pay us $100 or pay AAA $1,700. What do you want to do? So they still have a lot of incentives to bring these claims, unfortunately. But from our view, at least we are limiting the amount that we're willing to pay, and that goes into our analysis of, do we want to settle this, or do we want to move forward? We're more likely to move forward and defend if we're paying half the amount in filing fees than we are if we're paying the full amount. Does that answer your question, Brian?
Whoops, I'm sorry, I was on mute. Yes.
Oh, that's okay.
Thank you.
Good. Good. And so the final thing to consider, though, with these fees, and this one is really, really frustrating, is that there is a possibility for additional arbitrator compensation. And arbitrators frequently take advantage of that. And so what the rules provide is that these desk arbitrations should only take 7 hours and be limited to 100 pages. And sometimes these arbitrators will say, well, it's taking me way longer than 7 hours. And you all have exhibits that are longer than 100 pages. And so I need to be paid a whole lot more. And it's very arbitrary. And arguably, I mean, I've seen it where I've questioned the ethics of some of these arbitrators, especially when you're dealing with the mass volume, because they're only having to read something once instead of, say, 10 or 25 times. And so they're being compensated very handsomely already, but they do have that ability to request additional compensation. And what I do in that situation is I at least request an itemization, because usually they just send a bill that says, I think I should get $7,000 more. And so what we do then is we request an itemization, and then explain to AAA why we think that amount is unreasonable. But still, there is an ability for an arbitrator to really hike up the fees here. And that's one of the unknown factors when you're trying to figure out the value of these cases. Okay. And so again, who pays? Usually it's the business that's paying these arbitration fees. And the reason, or at least one of the reasons, has to do with the Concepcion case from 2011 in the Supreme Court. And in that case, the court noted that the Federal Arbitration Act allows arbitration agreements, and they're valid and irrevocable and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. So that means they're going to enforce these arbitration provisions unless there is a ground in law or equity that says it should not be enforced. And so that is where the state unconscionability doctrine comes in, because that is one such ground to revoke a contract. A contract can be revoked if it is unconscionable. And so that is why companies started including more consumer-friendly terms in their agreements, including that the business will pay all arbitration fees, because that way the actual arbitration provision with the class action waiver will be enforced. So to put it differently, the companies started accepting the risk that they have to pay for these arbitration fees in order for a court to enforce their arbitration provision with a class action waiver. So the thought was that by avoiding class actions, we're saving a lot of money and we'll suck it up and pay the arbitration fees. So that is why the business is paying them, but that is also what set the stage for mass volume arbitration. Okay, so we'll talk some about early strategy here and just talk about, what happens when you see that this is going on. I mean, there's a couple ways that these have come to me. Sometimes they come from a letter from opposing counsel. If it's a company that I've represented in individual arbitrations, we have a lot of the same consumer attorneys that come back time and time again. For any of you on this call, there's a good chance that you have run into Blake Thomas or Gregory Pierre. They are two of the attorneys that really push arbitrations on behalf of consumers, specifically against the payments industry. So many of you probably know those names, and I've dealt with them hundreds and thousands of times. And so as a courtesy, they may send a letter saying, look, I'm getting ready to file all of these arbitrations. And that might be the first time that you hear about it. And at that point, you're going to want to buy yourself some time. I'll move on to the next slide. But at that point, you're going to want to buy yourself some time to try to determine the merits and any possible settlement before the filing of the arbitrations. Because once they're filed, you're going to owe $500 in intake for each one. So that's one way it comes to us. Another way is that it may be too late. They may have already started filing these, and the company is bombarded with individual arbitration demands, often hundreds a day, and you're just praying that at some point it will finally stop. So the first one is the preference. Hopefully there's some relationship with the consumer attorney where this is done before filing, but that might not be the case. And so once you understand that you're dealing with one of these, like any case, you've got to look at the facts. You've got to determine, where do you have liability, if any, what would be the actual value of these claims. You're going to look at whether there are statutory damages involved. I would say most of the claims that we see involve statutory damages and attorney's fees. As we all know, attorney's fees for the plaintiffs are what drive so many class actions, and it's no different than with mass volume arbitrations. So you'll be looking at the claims. You'll be looking, of course, at the number of consumers to determine the aggregate filing fee that you'll be looking at. You'll be looking at whether somebody's a repeat offender, because, for instance, with Blake Thomas, there were a couple times where he came after a client of mine and we made the decision to settle, because we said, okay, it's going to be way, way cheaper to settle these for example, $100 than it is to pay $3,400 per claim and filing fees. We saw, that these claims weren't a slam dunk on our behalf either. So we made the decision to settle. That happened once, and we said, okay, that was a good economic decision. Then it happened a second time, and we went through the same analysis and said, okay, well, I guess this is, it's still a good economic decision. Let's go with it. But the third time we said, okay, we've got to fight this because they're just using us as an ATM. And so we're going to have to bite the bullet and start fighting this more aggressively, even understanding the fees that are going to be associated. The other thing that you're considering at these early stages is whether you can have buckets of claimants, as I call them. One thing that I do when I receive a mass volume arbitration is I try to say, okay, are there different buckets of valuation for different claimants? For instance, do some have no damages at all? Were some unaffected? Let's say, for instance, the consumer attorney is alleging that there was some kind of a system outage that delayed access to a consumer's account, and that this happened on a broad basis. We would then look at those consumers' accounts and say, did this outage actually affect the consumer? How long did the consumer not have access to funds? Was the consumer already provided with a voluntary, payment for inconvenience? We'll see how we can divide those claimants up. And then I usually will send a letter saying, this section of claimants, is completely without merit, and you need to drop these claims. And if you don't, we're going to seek our attorney's fees, and we'll get to that later. And we'll say, and here's another bucket where we're willing to entertain settlement negotiations early, and then we'll see how those negotiations go. So that's what I mean by buckets of claimants. And then finally, you're going to want to consider the timing of any settlement. Again, the best thing that could possibly happen would be, if you want to settle them before anything's ever filed, because you're saving all of the upfront intake fees at that point. Next best situation would be to settle after paying the intake fees, but before incurring any charges on the $1,400 case management fee and the $1,500 arbitrator fee. And then, as we discussed, the unlimited fee that an unethical arbitrator may try to seek for alleged hours that have been worked in excess of 7. So once you've gotten past, though, the payment of all those fees, there's really no basis to settle. I mean, at that point, especially, well, I should say, that's assuming that you have a good defense to the claims. At that point, you just move forward and you defend them. And so those are kind of the early considerations. Another early consideration would be fee shifting. And that is a great way to push back on opposing counsel. So there's really 2 ways that you can try to get fees shifted such that the consumer would have to pay the filing fees with AAA, and the consumer would have to pay your attorney's fees as defense counsel. And so that's always something that you should be considering when you're negotiating settlement. The first way you could do this is through Rule 44C of the AAA Consumer Arbitration Rules. And under that rule, the arbitrator can allocate compensation, expenses, and administrative fees to any party upon the arbitrator's determination that the party's claim or counterclaim was filed for purposes of harassment or is patently frivolous. So the standard there is, claim filed for purposes of harassment or is patently frivolous. Arguably there, you're only going to be able to recover your filing fees, though, because that does not really address attorney's fees. So the next mechanism is you look at the statute under which you're being sued. Here with IPA, it's very likely that it would be under the Electronic Fund Transfer Act. And that's where I've handled several mass volume arbitrations. And so under the EFTA 15 USC 1693M, it allows for the recovery of attorney's fees. And that states that on a finding by the court that an unsuccessful action was brought in bad faith or for purposes of harassment, the court shall award defendant attorney's fees reasonable in relation to the work expended and costs. So again, that's something to consider early is what are your chances of recovering your own attorney's fees? And like I said, that's one thing that you'll want to include in any early correspondence with opposing counsel. So after you've tried to find buckets of claimants and said, look, this bucket here, you really just can't state a viable claim. This person wasn't even a customer of ours, for instance. Figure out what absolutely lacks merit. Try to convince them not to file that or to withdraw that early, and advise them that if it's not withdrawn, that you'll be seeking attorney's fees and costs under the statute and under the consumer rules. So along that same line, if you haven't settled and things are moving forward, then you should consider whether you want to file counterclaims against the consumers in these cases. So with respect to the counterclaims, again, I would assert those under the EFTA and Rule 44C. I don't think that it's actually required to assert them as counterclaims because they really, aren't their own causes of action against the consumers, but I still think that it's smart to do so. The reason I say that is that a situation we faced where there were tens of thousands of arbitration demands that had been filed. Well, the opposing counsel started withdrawing these. Let's just say, for instance, because it wasn't anybody who had ever used our product. So they said, okay, well, we'll withdraw those. And it's like, well, thanks for withdrawing 10,000 arbitrations, but we already paid $500 for each of those. And so what is that? Is that 5 million or 500,000? It's a substantial amount of money. And so, we appreciate the withdrawal, but the problem is we're still out a lot of money. And so one way that we could guard against that happening was by asserting our fees as a counterclaim. Because just like in litigation, if you have a counterclaim pending, then the court is not going to dismiss the full action, even if plaintiff's attorneys say they are going to dismiss their cause of action. And so we put the same strategy at play here. So the consumer arbitration rules don't specifically address that situation, but any arbitrator who we had to argue on this issue before was ruling with us because it just makes sense that if we have our own claim pending, they can't withdraw it. And at that point, we can say, yeah, we're going to move forward and we're going to seek our fees on this claim because it should have been withdrawn. Along with that, you can show that letter that you sent early on that said, look, this claim has no merit and you need to withdraw it or we're going to seek our fees. So that's why I think you want to have a counterclaim in place for non-meritorious claims. And by non-meritorious, I mean those completely lacking any merit whatsoever. The next thing that you want to consider in the counterclaim is that you want to seek the fees directly from opposing counsel. So this is another way that you're trying to provide some leverage against opposing counsel, because so far they've got all the leverage against you. They've got these huge filing fees that are accumulating. And so you say, okay, all right, we see that, but these claims really don't have merit. And so not only are we going to seek these fees against the consumers, but we're going to seek them against you directly. And there are a couple ways that you're allowed to do this. One is through Rule 44A of the Consumer Arbitration Rules. And that says that an arbitrator can grant any remedy, relief, or outcome that the parties could have received in court, including awards of attorney's fees and costs in accordance with the laws that apply to the case. So then from there, you might want to look at the state substantive law that applies. For instance, my clients often have a Utah choice of law provision, and that says that when an attorney, under Utah Rule 11, when an attorney files a pleading, he or she's certifying that the pleading is not filed for an improper purpose or for harassment. And if it is, then they provide attorney's fees. And then you can also look at the attorney's state of residence. For instance, in Florida, there's case law that says these fees can be recovered directly from the consumer's counsel. So a little hint for anybody dealing with Gregory Pierre, he is located in Florida. And so we've been able to get fees directly against him. It's not easy, and he avoids paying. He actually was, I think, disguising himself to avoid service once we moved to certify the award, but we did finally get it. So that is a lot of leverage that you can use against these attorneys when the mass volume claims really lack any merit. So let's see, it's already 2:36. So I'm going to go through the appointment of the arbitrator fairly quickly. So early on in the process, then once you've decided this isn't going to be settled, it's going to have to be arbitrated, then an arbitrator will be appointed. And what happens is they send you a letter that says, we've appointed, Joe Smith as arbitrator. You have until a certain deadline to object to the appointment of the arbitrator. This is different than what you'd see in the commercial context, because under the commercial rules, they'll send you a panel and you basically go back and forth based on that panel and see if you can come to an agreement on the arbitrator. But here it's just one that's chosen and you have the opportunity to object. And so what you do then is you consider, for one thing, when you're receiving this communication, you're considering at that time whether this arbitrator is someone who might do the arbitration in panels where they would hear multiple claims at once. And you're also negotiating with AAA about whether AAA is going to assign these in panels. And what we found is that even if opposing counsel does not want panels because they want to make things as difficult as possible, AAA is still going to assign several arbitrations to an individual arbitrator because that's all the capacity they have. They don't have 70,000 arbitrators just ready to jump on an individual arbitration. And so instead they're assigning, depending on the size of the mass volume arbitration, maybe 10 cases to an arbitrator, maybe 25. And so you'll see that coming through and you'll start considering, okay, what can we agree to start having some administrative efficiencies to maybe keep some costs down. But as far as objections go, there are two different rules that apply. So under AAA Rule 19, you can object to the appointment of an arbitrator, but the AAA will only disqualify this arbitrator if he or she shows partiality or lack of independence, or two, the inability or refusal to perform duties with diligence and in good faith, or three, any grounds for disqualification provided by applicable law. So you have to show that there's some form of bias here. I can say that we've had some success in getting arbitrators disqualified. Some success stories would be where the arbitrator's oath or resume shows a history of representing consumers against financial institutions. That's been accepted. There was, there was one time where there was an arbitrator who I previously had, and the decision was clearly results oriented because the arbitrator didn't rely on anything that was said by either party and just went completely on his own. And that showed that he was unwilling to perform his duties with diligence, and also got an arbitrator disqualified when they had issued a decision lacking any reasoning whatsoever.
Libby, if I can, I'd just like to have another question.
Sure.
What are the qualifications for an arbitrator? So do you have to be an attorney? Are they former judges? Can it just be someone who does this full time? How does one become an arbitrator?
Right. It's some of all of the above. Usually what you're seeing more senior attorneys and retired judges, and also retired attorneys that now do this for a living. You'll see all of those. I think AAA has to approve the arbitrator to add them to the panel. And so, of course, they want this arbitrator to be someone who is seen, at least on their resume, as having an impressive career and impressive credentials. often in the arbitration provisions themselves, you will specify that the arbitrator has to be an attorney with at least 10 years of practice or a active or retired judge. That's something that you'll see a lot. That way you're not just having anybody off the street deciding these claims.
And then as a follow-up, as a non-litigator, as you mentioned, there are times, and I'm sure they happen more often than we acknowledge, where an arbitrator ignores the facts on his own from either party and decides to give their own ruling. So is that ruling still binding, or is there a way to appeal that ruling? What happens if that situation arises?
Well, that's the problem with being in arbitration. And so it's a real problem too, because for instance, we can look at the law and say, look, we've got a slam dunk here, and we might win, 9 out of 10 of them though, because the arbitrators, they don't have to follow the law. They don't have to follow legal precedent. They can go rogue. And that's a problem. And what's really frustrating is that, well, let's say you've already, arbitrated 100 of these to a decision. Let's say you have thousands more out there, and you've arbitrated 100 of them, and you've won 80 or 90% of them, which has happened in our cases before. Well, you'd like to be able to say, almost everybody's ruled in our favor. Shouldn't you do so? And they almost take pride in saying that every single arbitration is different. I don't have to rely on anybody else. None of these are precedential. So that's a risk you're running when you're in arbitration.
Thank you. I've always wanted to know that question because, like you said, you agreed to go through this process, and the arbitrator has more authority than I think sometimes people realize.
Exactly. It's almost impossible to appeal. There's a rule in the consumer arbitration rules that basically says that you can have, bring to the arbitrator's attention a clerical error, but that's more just like an error in calculating damages. You don't even have a mechanism to say, hey, but you didn't consider my argument over here. So it's really a frustrating process. And what we found when we're searching for arbitrators and who we'd like to disqualify if we can, the worst offenders seem to be professors or retired judges. Those tend to be the ones who most often go rogue. And one interesting feature to the mass volume arbitration that I've seen is that one would expect an arbitrator who has, say, 10 claims that are substantially similar, he would decide those 10 claims the same. But it's been counterintuitive because, especially with these retired judges or professors, they seem to want to dig in and try to split the baby somehow and say, well, this one case is different over here. So consumer attorney, you win this 1 out of 10. It's not a complete goose egg. And unfortunately, that's enough to keep these consumer attorneys going. And sometimes to keep them having funding coming in, because if there's a fee award in their favor, all of a sudden you're continuing to fund them. So that's a real problem, that there's really no appellate mechanism and no precedential value to arbitrations or requirement to follow the law. As an aside, really at the beginning of the pandemic, I was surprised that claims we are usually winning on an individual level for about 2 months, all of a sudden started shifting over to the consumer. And the only thing that made sense was because it was the first days of the pandemic and people were freaking out and they didn't want to award something to a company as opposed to the poor consumer who all of a sudden, may be out of work and doesn't know how, doesn't have any income coming in. So yeah, it's frustrating when there's no appellate mechanism. So second, on the objections to the appointment of the arbitrator, there is also the California rule and the California rules of civil procedure. And that allows you to object on any basis whatsoever, so long as it's something that's within the arbitrator's oath. So each time you get an arbitration appointed, the arbitrator has to sign an oath, and it tells you, a number of facts about, the type of work they've done, if they know of any of the parties or any of the attorneys. And you can look at their resume as well. And so you can basically object without cause if you're governed by California law. And there's cases in California that say if California law is governing the arbitration, then any arbitrator appointment objections are superseded by California law. So the AAA rules, that required impartiality or proof of partiality, those are superseded by the California rule that says you can object for no cause whatsoever. So long story short, if it's possible for California to apply, consider that, because you have much better ability to object to the appointment of the arbitrator. Okay. So next, you're going to have a preliminary hearing with the arbitrator, and I'm going to start going through these a little faster, realizing where we are on time. When that happens, usually panels have already been put in place, and so the arbitrator has multiple claims, and the point is to set a briefing schedule. But you also, in the mass volume context, will probably have some pretty substantial discussions about Rule 22. So if you have an individual arbitration, it's pretty easy. Both parties just say, we're going to produce whatever we plan to rely on in our arbitrations, and you go from there. When you're in a mass volume arbitration, it gets a lot trickier because opposing counsel will say, well, look, we have all of these different arbitrations, and for each one, we need some different information. And they're doing this on purpose to try to make the costs accrue for the defense of the claims. And then we have to basically fight it out with the arbitrator and explain that the consumer arbitration rules are supposed to be much less burdensome than federal discovery, explain that it only involves a document exchange, that it doesn't allow for interrogatories or requests for admissions or depositions. I think that the commercial rules actually allow for specific document requests, but that's not allowed in consumer arbitration. And so we have to really educate the arbitrators about the consumer rules, because lots of times they don't know. It's great when you can seek an agreement with opposing counsel saying, this is the universe of documents that's going to be presented. Here's everything that's, that applies to all claims, such as policies, things like that. And there's only one or two documents that apply to specific claimants. We'll produce both of those, we'll be done. But again, they don't have incentive to agree to that. And so lots of times there's a fight at the hearing about that. And there's also a fight about whether depositions can take place. Again, there shouldn't be any depositions. So I will say, just going back to that though, that if you're in the call and you're having an arbitrator that's receptive to their arguments that are more similar to federal discovery, then the best strategy then is to push back and say, okay, if they get that, then so do we, because they don't want to do any work. Their business model is built upon trying to have an early intake, trying to settle early, and then not really having any further communications with their clients. Usually they get an affidavit up front. So if you push back and say, okay, well, if you're going to seek documents from us, then we're going to seek documents from you. For instance, even something simple, I'd say I'd want all the tax returns for each of your clients for the years in question. And once I started doing that, opposing counsel freaked out because it's going to be very hard for them to try to get all of those. So that's how you kind of use some of that leverage and see if you can seek some agreement. So next, we'll talk about briefing class action, mass volume arbitrations. As you can expect, we're going to be doing this by development of templates. For instance, with the EFTA, that you're usually seeing two different factual patterns. One would be alleged unauthorized transactions, and one would be alleged improper holds. So you'll develop templates for each of those briefs. There's also, when several thousand arbitrations are involved, that's when you might want to get your litigation support team involved. And so, for instance, in the one where we had 70,000 arbitrations and 4 law firms that were working together in defense, we found, one of our teammates had the ability to automate some of the briefing so that it just required a minimal review of specific facts, and that could be done from less experienced attorneys after the more experienced attorneys put the briefs together. We also did something called omnibus briefing, where we would have one brief that had all the main facts, and then we would have attachments of 2 or 3 pages for each specific claimant. That way you're not briefing the same law over and over. Because again, one arbitrator might be hearing 10 or 25 of these at a time. So just have them read one brief and then have attachments. One thing to also consider is we would attach a declaration from one of our attorneys with a scorecard of wins. Because again, most of these claims lack merit. That's why we didn't settle them early, for instance. And so we'll say, look, 100 of these have proceeded. We've won on 90 of them. And that's an effective way to address the mass volume of these claims because, as I said before, arbitrators don't follow any precedent. So you can attach those 90 decisions and they'll say, well, we really don't care. But, a short and sweet way to do it is through a declaration. And then finally, I'll say with respect to briefing that when we can have these panels of arbitrations, it's a benefit to us, the respondents, the defendants, because we do a little bit more work than the Consumers Counsel do. So they're going to see briefs, filed by Consumer Counsel and filed by us, and they'll realize that every single brief looks the same from the Consumers Counsel, except for an affidavit that's signed by the claimant, but almost all of those affidavits even look the same. And so, it then casts doubt on their credibility because they're all alleging the exact same factual situation happened to them. And that's just not really realistic. They're talking about, multiple times I contacted the company, multiple times the company refused to call me back, things like that, that when you just see it over and over, you realize this, there's a lack of credibility there. And so for us, we spend a little more time with making sure that we are presenting all of the relevant facts to that specific claimant. And so that's one benefit to having these panels. Just quickly, I'll say you also want to separately brief attorney's fees. That way you're not having to do it up front and you're only briefing it at the end if there's any award to either party of those fees. And that's after you've also been able to see a duplication of effort from the template briefing. So we only have a few more minutes, but I'm going to provide a few things to consider to avoid the extortion of the mass volume arbitration. And, so basically, how do you get yourself out of this situation, or more specifically, how can you avoid ever being placed in the situation? Once these have been filed, things aren't going well. You're already going to have to pay a lot of money. And that's why I say it's extortion, which I've defined here. So ways to avoid, defend and don't settle. Like I said, if you've got a repeat offender and you've settled a couple times, it might be time where you just have to say, fine, we're going to call your bluff. We're going to defend. We're going to make you do work. We're going to make you spend time that you may never recover. We've told you why these claims don't have merit, and we're going to make you try to prove them. And, we're not just going to have an extorted settlement. It's hard. I mean, the companies where we do this, these are, Fortune 100, Fortune 500 companies who are willing to say, we've got to, put our money down now. But sometimes that's what you need to do. It's easier to do when you have 100 than it is 70,000, but we called their bluff on 70,000 and, eventually got to a much more reasonable settlement than what they were trying to extort at the beginning. So that's why I say keep pressure on claimants' counsel, force them to contact their claimants. They don't want to do this. The claimants, they've only had probably one interaction with them. It was probably online. This is counsel driven. The claimants don't even know what's going on half the time. So that's why I say forced individualized document production. Again, you're making them do work, which is going to cause them to reevaluate the cost of the settlement. Another thing is you're going to want to consider whether you really need an arbitration provision with a class action waiver. When you have these mass volume arbitrations, you look at, you say, daggone it, I wish this was just brought as a class action. It would be way cheaper if this was a class action. You're paying one filing fee. You're not paying these multiple filing fees. Amazon has actually taken this approach in response to a mass volume arbitration. And they said, fine, file class action against us, sue us. There are benefits, as Brian and I discussed earlier. that there is, substantial judicial review with a class action. They're bound by precedent where arbitrators aren't. And so if you feel really confident, then it's going to be better just to have a class action. So there's other things you can do, though, to avoid the situation. And there's revisions you could make to your arbitration provisions. And so some things, and most of these have not been tested yet, because mass volume arbitrations have only been going on about 4 or 5 years. And so we haven't really seen the swing back from the companies of what they're going to put in their arbitration provisions to avoid the situation. So some things that are considerations that haven't really been to before the court would be revisions such as requiring specific notice to the company with an opportunity to resolve prior to the filing of the demands.
Libby, I want to just thank you. I know we're at the top of the hour and we're respectful of your time and those on the line. There is a lot of information here to digest. And yes. I do want to just pause and feel free if anyone has a question while we have Libby. But I wanted to make sure that you shared your email, or people can email us and forward that on to you.
Yes. So what I'll do, we are at the top of the hour. And so I'll kind of leave it to the attendees to go through these other considerations. But you'll see, that, perhaps consider not having the fee shifting provision, perhaps consider a cheaper alternative for the forum, and perhaps say that only the defendant can opt out of arbitration and resolve claims through class action proceedings. And so my contact information is right there. And so anybody who wants to discuss it further or has any questions, they can feel free to reach out to me. Or if anybody has any questions now, I'm happy to answer them as well.
Again, I know we're running out of time. If you have a question, please put it in the chat, or you can email me after today at btate@ipa.org. I'd be happy to pass that along. But please take note of Libby's contact information. This has been an excellent presentation. There's so many factors and things to consider. So this should not be something you jump right into. This should be something that you plan out, think about, and carefully enter knowing all the ups and downs here. So I do want to thank Libby for her time, and that we very much appreciate this, and that we will invite Libby back if anyone has questions. And this will be an ongoing thing for all of us going forward in terms of how we interact with our consumers who have concerns or other third parties. So thank you.
My pleasure. And like Brian said, anybody can feel free to contact me. I'm happy to help with any questions you have, or just discuss any strategy if you find yourself in this situation.
Well, thank you, everyone. I hope everyone enjoys the rest of the day. Please stay safe, and we'll be in touch with everyone. Thank you.
Thank you. Bye.